Well, good morning, everybody, and thanks everybody for being here today. My name's Tom Pirelli. I'm a partner at Jenner & Block here in DC, and I'll talk a little bit about my background as we go forward. I think as you see from the program, we've got a couple of panels this morning, I think both of which will talk about banking regulation to some extent. I think our panel is likely to focus a bit more on the debate surrounding Dodd Frank and some of the practical implications of it. And then the next panel may provide a more academic approach to it, although as Professor Sharkey mentioned to me, that means that you may find two panels that are talking about the same subject and you will have no idea that we are actually talking about the same subject. Let me first introduce the panelists. All the way down to my left is John Ryan, who's president and CEO of the Conference of State Bank Supervisors. And as I think folks know, the conference represents state banking supervisors, and with them, they're really on the front lines of regulation of financial institutions at the state level. Among other things, John was previously on the House Banking, Finance, and Urban Affairs Committee as a staffer. And then to my immediate left is Andrew Ullman, who was recently the Republican Deputy Staff Director and Chief Counsel at the Senate Committee on Banking, Housing, and Urban Affairs. He had a pretty busy tenure there, particularly in the 2008, 2009, 2010 period, seeing us through the reform of Fannie and Freddie, TARP, Dodd Frank, where he was the lead staff negotiator. And in his past life, he worked at Mayer Brown and at the Federal Reserve Bank of Richmond. I think both of them are going to be able to give you an on-the-ground view of the debate that led up to Dodd Frank, as well as some of the debate since and the impact of the statute. I think we're going to structure this. We're each going to talk for 5 minutes or so at the outset, and then sort of break this down a little bit into sort of talking a little bit about before Dodd-Frank, the negotiations around it, and then maybe the world sense, and obviously leave time for questions. Let me give you a little bit of background about myself and sort of where I come at this. I am a serial employee of the United States Department of Justice, having started there as a computer programmer when I was 19 years old and having been in and out of the Justice Department 6 times. In addition, my father worked there for his career, so I've spent a lot of time in that organization. My last stint, which was from March of 2009 to March of 2012, was as the Associate Attorney General, which is the third ranking official in the department, overseeing all the civil litigation in the United States, so civil rights, environment, antitrust, tax, and that includes sort of all of the high-profile federalism litigation you can imagine, whether it's Arizona immigration, the Affordable Care Act, and a host of other things. Also in that role, I sort of had a lead role in working collaboratively with state law enforcement of various kinds, everything from police departments at the local level, where I oversaw our funding of police on the street, domestic violence shelters, after-school programs, a host of things like that, about a $4 billion budget in the least lean years, but also working with state attorneys general on antitrust and consumer protection matters. And in particular, I was the lead negotiator for the United States on the $25 billion mortgage settlement, which was a massive investigation and settlement with 5 national banks, 4 national banks and 1 bank that's still trying to figure out what it is, right? In that context, I think you saw a lot of the practical implications of Dodd Frank and how it changed the world. And I guess so I will talk a little bit about that. Let me start sort of going back in 2009, because I think Dodd Frank is part of the story as we go forward, but thinking about how federalism, and particularly in preemption, looked different than maybe it does today. Because I think part of that story is less about the development of the law and less about what statutes Congress pass and less about what federal agencies put in their preambles about preemption of federal law, and more about the kind of collaboration that makes federalism really work. And so when we talk about federalism, a huge component of that is really the day-to-day interactions, and I think, as the governor talked about, communication, the day-to-day interactions of folks enforcing the law, how they work together, whether they work together, and the actors on that stage have as big a role in how we think about the operation of the allocation of power between state and federal authorities. As I think folks know from the outset, the Obama administration wanted to chart a bit of a different course on preemption, and the president issued his memo on preemption in 2009. And I think you saw many agencies, not every agency, but many agencies take that into account in their regulation and rulemaking. But central to that message was also a message that we needed to be deeply engaged with our state counterparts at every level, working together to enforce the law, recognizing that there were some things that might be smarter for the feds to do. There were some things that might be smarter for state authorities to do, and some things, frankly, that might be smarter for local authorities to do. One of the very first things that Attorney General Holder did was bring everything from local police chiefs to state attorneys general together in a meeting that had no message other than we're back and we want to work with you. And we got an enormous amount of frustration expressed to us out of that meeting that there hadn't been. Forget about what the law said, forget about sort of litigation over preemption, forget about all of the other issues. There just hadn't been a lot of discussion about how we should be working together. That's not to say that there weren't innumerable examples of wonderful working relationships, at the state and local level between federal and state officials. But on a mass scale, whether it's philosophical and practical, that discussion had broken down to some extent. I remember when I went out to Colorado to visit with the state attorneys general, and I probably got one paragraph into my spiel and got a standing ovation, and I didn't even know why. And it turned out it was because I showed up, because a senior official for the Justice Department actually went. That's my best I had them at hello speech I'll ever do in my life. That's all backdrop, and I want to sort of lead up and talk a little bit about Dodd Frank and the national mortgage settlement. I know I'm going a little over the 5 minutes that I said I would. Folks, remember a little bit the backdrop of issues related to mortgage servicing. In fact, I think the New York Times reported today that the OCC and the Fed, their settlement with the banks, the checks went out and they bounced to homeowners today. So that was not a good result. Not my settlement, I don't think. Anyways, that started with an issue, robo-signing, and I remember very clearly immediately after the disclosure of all these issues related to foreclosures that all the federal entities got together, none of the state entities, all the federal entities got together and talked about sort of how they were going to deal with this and what they were going to do. And even within that room, you had, you had 7 or 8 agencies, all who were going to go in a different direction. And it sort of, from the outset, you saw that, well, geez, if even the federal feds could get together, we actually might be able to move something more productively. But at the same time, the state attorneys general were already actively engaged and working on this. And when you think about what that moment in time looked like, what you I think saw was a moment where you were steaming towards huge federal-state conflict. You had mortgage servicing, an area conducted, where 80+% of the activity is conducted by national banks, overseen by the OCC, and not only overseen by the OCC, but in an area in which the OCC was currently conducting investigations and was planning to issue orders that would define what the banks needed to do to cure the problems and establish new rules of the road. At the same time, you had state AGs focused on something that at one point in the past was inconceivable, which was imposing detailed standards in a particular area of national banking, as detailed standards and procedures on them for servicing mortgages, and with a monitor who was substantially overseen by the state AGs and the state banking regulators. This was a joint effort by John's folks, the state banking supervisors, and the state attorneys general. And so when you think about that, it's at that moment in time almost inconceivable that you would find a path forward without a collision on federalism. The notion of a monitor overseeing national banks with the state banking supervisors and state attorneys general having a substantial role over that was something that, frankly, the folks who had worked in this space for a long time said it was impossible to envision. It just would never happen. in the midst of all this, Dodd Frank had a very substantial role to play, I think, because it did, notwithstanding what the discussion I think we're likely to have about what did Dodd Frank really do about preemption and the OCC and all of that stuff, it was a statement about the importance of the role of state regulators. And it also was an area where, and was a moment that said, okay, we're going to have to find new working relationships together. Obviously, there's going to be a new regulatory body, the CFPB, but we're going to see the banking supervisors at the state level, OCC, all of the federal entities having to find new ways to work together. And the mortgage settlement was, in some respects, a first opportunity to do that. We had many challenges from beginning to end. Somewhere in the middle of this discussion, the OCC proposed their rule on preemption, which was not well received, I can say, by many at the state level. But what we saw throughout that process was tremendous collaboration, and including by the OCC. So the OCC, FDIC, and the Fed all working collaboratively through the Justice Department with the states to reach a result, including, exceptionally detailed standards for the servicing of mortgages that, again, apply to 80+% of the market. We talk about philosophically about the notion of cooperative federalism. This was it's not really what people think of when they think of cooperative federalism. It's more of a legal term, but it was an exceptional example of that. And I think it showed a shocking amount of cooperation that made a lot of sense as a matter of federalism. Let me say one last thing about Dodd-Frank, and then we'll move on. I remember vividly getting the first draft of what later became Dodd-Frank, and being given, I think, 17 hours to review it in its entirety and comment on it. But one thing that stands out for me, in addition to trying to figure out what this thing that didn't have a name yet, but ultimately became a SIFI, systemically important financial institution, but didn't actually have a title at the time, was the very clear notion that this was that one goal was to change the way states and the federal government work together on regulating financial institutions. Now, there's a long and complex story with the negotiations over Dodd-Frank and the enactment, but I do think that there was a great deal of promise from the outset, and my hope is in the future that there will be some success in really fulfilling that promise as time goes by. I'm going to turn, I think, first over to John to let him talk a little bit, and then about his background and experience, and then obviously thoughts on Dodd-Frank, and then Andrew, and then, like I said, we'll get into sort of breaking this down into sort of before, during, and after kind of conversation. Thank you.
Thank you, Tom, and it's a pleasure to be here with all of you. So I wanted to give you a little bit of the history from our perspective, and that's the perspective of state regulators, generally appointed by governors, responsible for the chartering and supervision of banks, but also a lot of non-banking, increasingly over the years, non-banking activities. The state system accounts for about 75% of all banks in the country, but a much smaller percentage of the assets, about 30% of the assets of the banking system. This debate of federalism in financial services goes back to our founding, and the question of what's the federal role, what's the state role. It took a long time in the course of our history to establish a federal role in banking, and I think from where we sit as state officials, we see a strong federal interest in banking. There's no question about that. What it's come from is a discussion of federalism and what's the federal role to is there a state role, should there be a state role? And that's where we found ourselves prior to Dodd-Frank. So one of the concerns, and this is consistent through time, is that a federal role would lead to a concentration of power and decision-making around banking in a handful of a few, and credit decisions being so distant from the borrowers that they weren't aware of the consequences or they weren't receptive to the needs, that money would be funneled up from communities into centralized institutions and diverted elsewhere. That's, in the 18th and early 19th century, we're talking about that. It is still the issue today. And what we're fighting for at the state level is that local economic self-determination, that you can have a diversified system, a system that allows for, doesn't create such high barriers to entry, and this is where most of our foreign counterparts are, such higher barriers to entry that allows for local money to get together, form a bank, they have to be approved by states, by federal regulators, the leadership, the owners, but that you can use the leverage of the banking system to benefit local economic development. That's kind of at the core of this. And what has become ancillary to that is that you also are able to protect consumers locally, that there's local accountability. Where we got to and where we came from was a question of whether there should be any local accountability for as I said, the largest institutions fall under the national charter. There's a reason that they've chosen that, and this preemption history has a lot to do with it. They want to be able to operate accountable to one entity in Washington and not to 50 states, not to 50 state laws, not to 50 state enforcement, et cetera. You can understand that motivation, but what we really see in this financial crisis is why that's such a challenge and why so problematic, and how we see the local consequences of that lack of accountability. So there were a series of Supreme Court decisions, probably not focused on these grander questions and the consequences, that backed up the OCC's authority. First, it started what goes back to issues around expectation of interest rates, but I'd say one of the most important decisions was back in 1996. The state of Florida said national banks could not engage in the sales of insurance subject to state law, and the OCC said, well, we authorize the sale, our banks to sell insurance, and that went all the way to the Supreme Court. The Supreme Court said you can't block the state. It didn't say you can't do anything, you can't condition, but it said you can't stop a national bank from engaging in the powers authorized to it under federal law. That was extrapolated to the point of that you couldn't condition in any manner the operations of a national bank, and then it was extended to their partially owned subsidiaries. They're not a part of the bank. They're separately incorporated under state law. It then was an attempt to go out to the agents of national banks, this broad net of protection from state authority. A turning point, we had a decision that around mortgage really became the turning point that focused people's attention on this issue. States starting to pass predatory lending laws. A court issue went to the Supreme Court over whether states could regulate the operating subsidiaries of national banks. We lost that decision. The crisis happened, and another case came to the Supreme Court about whether states could enforce state laws against a national bank that had not been determined as preempted. And these were around fair lending. So this is known as, started under A.G. Spitzer, became known as the Cuomo decision. This was a turning point for the Supreme Court, and this really fed into Dodd Frank and changed the dynamic of federalism in Dodd Frank. And the Supreme Court found as they saw the extension of the OCC's arguments around what its authority was and what the state's authority wasn't, they said only we can enforce, the OCC, any applicable law, state or federal, against a national bank. And so the Supreme Court sided with the states. This completely changed the dynamic in Dodd Frank. If we had lost this one, then I think you would have seen much broader preemption and less recognition of the state role. So that was an aspect. But another thing that was really important to a better understanding of the challenge we faced in the states was in 1997, a working group and it started back in 96. Some members of Congress tried to reconcile these differences and brought together us, the AGs, the Comptroller of the Currency's Office, and said, can't you work some things out here? And there was some discussion about that stopped. And they stopped right around the time of the Cuomo decision, and the OCC sort of just pulled out of this discussion, and then things started moving. At that same time, the states were seeing a lot of issues around foreclosure, and one of the attorneys general called together a group of all the state AGs, invited myself and some others from the regulatory side, including federal regulators, to talk about these issues in early 1997. Out of that came this working group that was looking at an increase and an expected increase in foreclosures. From that came a meeting with the top 20 servicers, many of whom were national banks. And in these discussions, we had a meeting in Chicago, closed door, off the record. In that meeting in Chicago, a number of the large servicers said, one of the challenges is we're not able to reach the borrowers. We're not getting a response back to them. We're trying to modify loans, but we're not hearing back from them. States, both banking, mortgage regulators, and AGs, were hearing a different story, and they were contacting these servicers when they're trying to help a consumer, and they get one person, and then they're never able to reach that person again, and the file's lost, and then they try to get another person, and the servicers seemed to us to be overwhelmed by the foreclosures they were receiving. So we asked, we'd like some information around what does it look like? What are you going to see? What do delinquencies look like? Are we going to expect more foreclosures? Before we work together with you to make outreach to consumers, contact your servicer, we want to know where we should be focusing our efforts. We want to know that once they get to you, that something is going to happen. We were totally stiff-armed, and the OCC came out with an interpretation that said, we will not allow these institutions, at the request of the institutions, to share any information with you. So foreclosure, a matter subject to state law, that was going to come to us one way or another. We're trying to understand what the volume is going to look like just to see some reporting around this. We won't even talk to you. We won't even share any information. That resonated with Congress. It seemed ridiculous that we couldn't even know what the problem was going to look like when they had information, and that some institutions subject to state jurisdiction shared the information and others didn't. So that fed into Dodd Frank and a consideration of what the right balance should be, but the consequences became much more real, the issue much less theoretical. State organizations had come together, the NGA, the NCSL, NAG, the AGs, ourselves, mortgage regulator. I mean, we had a whole host of us who continue to be affected by the consequences of this federal preemption come together, and that made a significant difference.
Thank you, Tom. First, I'd just like to thank the Uniform Law Commission for giving me this opportunity to come and speak. As Tom mentioned, I've had a very eventful tenure at the Banking Committee, and this is one of the first chances I've actually had to talk about some of my experiences and to give a perspective of what it was like to be involved in the negotiations, and kind of give you, hopefully today, a broader view and maybe a little different view of how to look at what Dodd Frank did. Because I think Dodd Frank is certainly going down in the history books as one of the most important, substantial rewrites of financial regulation in our history. And I think, for the topic today, one way you can look at Dodd Frank as a common theme is about the transfer of power. Almost every title within Dodd Frank involves a transfer of power, usually from either the markets or from states to agencies in federal agencies, either existing agencies or new agencies. It's a common theme that if you were just thinking about purely preemption and kind of the OCC, which usually gets the headline, that's certainly one slice of a piece of Dodd Frank, but it's also, Dodd Frank is 2,000 pages, and I think those pages are probably 6, 7. The other 1,900 plus pages involve a great deal of preemption and transfers of authority between markets and the states to Washington, and particularly the federal agencies. If you just go through the titles, SIFI regulation will mean that insurance companies and other large institutions that right now are largely supervised or chartered by states will come under regulation, not only federal regulation, but federal regulation by the Federal Reserve, kind of the mothership of and dominant financial regulator in our system. The resolution title, Title II, will mean that insurance companies, which right now are resolved under state law, the resolution of a large insurance company would likely occur at the federal level going forward. If you look at the expansion of the authority the Fed has under the bank holding company, it will now have extended authority to examine and get information from and take actions for subsidiaries of bank holding companies, non-depository subsidiaries that are largely state entities right now. If you look at the derivatives title, we've taken an over-the-counter derivatives market, which was largely based on state contract law, and transferred it to exchanges that will be regulated by the CFTC and the SEC, and to a limited extent the Federal Reserve. And then, probably most importantly, it's the CFPB. The preemption that and kind of transfer of authority from the states to the federal government, it's probably the most predominant and most clear to be seen there. And going through that title reveals that going forward, entities that were traditionally regulated by the states, mortgage broker, originators, kind of non-bank depository institutions, will now be regulated by the CFPB here in Washington. The CFPB has a very, very broad authority with its new enhanced UDAP rule to enforce unfair, deceptive, and now abusive acts against any provider of a financial product. There are very few carve-outs, and as we've recently seen, the Bureau is interpreting those carve-outs very narrowly. That's an area that was traditionally, for 200 years, largely something states did, particularly state regulators. That authority now, with enhanced supervision, not just enforcement, but supervisory authority being created at the CFPB, means that the main player now will be here in Washington. It's not in the states. And then in addition, there are enhancements to TILA, which will, I think, expand the amount of the federal role, and particularly the CFPB's role in disclosures, and potentially raise some additional preemption issues, because those amendments are pretty stringent, and it'd be very easy to be inconsistent with existing and potentially new state laws on disclosure. So, from my perspective, that the OCC portion of this was certainly part of the discussions, and it was something that in the lead up to Dodd Frank there was some discussion of. But actually, my memory of it, and actually looking back, the bigger issue and the one that was more of concern around negotiation was what to do with the non-bank entities, and that the main argument at the time was that non-bank entities were not properly supervised, and that they went out and engaged in predatory lending and other misconduct, and created and underwritten mortgages that should not have been underwritten, and that fed right into the financial system. There's one of our critiques at the time was that we thought Congress should take a very careful examination of what actually happened, what entities were involved, and where the oversights, regulatory failures were. Unfortunately, Congress decided to write the bill before it actually went off and studied something. It's interesting, if you go back and look at the New Deal, they had the PCORA Commission was created to go off and examine practices on Wall Street. And PCORA, certainly a very controversial staffer. Looking back on it,
do you wish you had a commission named after you?
Yeah, some of the things he did. But one thing I have to give him credit for as a staffer, looking back, is he was serious about getting to the bottom of what happened. And a lot of the work he did helped make for an informed decision-making process. At that time, Congress, in this case, didn't do that. They just kind of jumped and made a statute largely based on kind of news headlines. And so the statute, I think, reflects sometimes inconsistent theories of what happened, and that means that the bill, it's not always easy to understand what if Dodd Frank was going off to solve a problem, it's unclear what the problem it was trying to solve is, and whether or not it still exists. That didn't stop Congress in this case from moving forward and simply transferring authorities. And I think in many respects, one way to look at Dodd Frank is Congress saying, well, rather than us figure it out, we're just going to give the agencies a lot more authority and a lot more power and say, you guys figure it out, make sure this doesn't happen again, good luck. Our critique at the time was that's not really a great way to make sure that this doesn't happen again. Just throwing more authority doesn't mean it's going to be exercised in a better manner. As we've already heard, there's been a lot of questions about the use of some of the authority by some of the federal regulators, and whether or not we could have kind of improved the incentives on regulators to get it right. So you can see from a preemption and federalism standpoint, Dodd Frank is in many ways potentially could be a turning point on the allocation of going forward, that all the dominant players in financial regulation will be here in Washington, as opposed to out in the states. And even the OCC, which there was a fair amount of criticism was, I think it's pretty clear, and I know there's some controversy about this, is that largely Dodd-Frank codified the Barnett decision. And at the time, that was, I think, what was understood, and that there was a trimming of its authority, mainly by codifying the Waters and Cuomo decisions. And so, if you really look, and I think one could actually argue that the OCC went a little bit beyond its statutory authority, and Congress trimmed its sails slightly, but left Barnett intact. And so preemption at the OCC, for all intents and purposes, is kind of back to where it was. And there hasn't been a real sea change there. Whereas if the real sea change is in the world of non-bank entities, where the Consumer Bureau now will be the dominant player. So that's kind of my overall arching perspective on it.
And what you have just heard is what I think you heard before Dodd-Frank, during Dodd-Frank, and after Dodd-Frank, which is very different views about what actually happened here. And you see that playing out in the litigation, I think, post Dodd-Frank, and you saw that even the day the bill was passed from, I heard the great, this is a tremendous help for state regulators and is going to expand the role of the states in governing our financial institutions. And I also heard, wow, now this is going to be, the feds are all going to be, the feds are going to control the economy, and some people thought that was good, some people thought that was bad, but very different, and are going to be intruding more into state authority. And I guess I want to go back to John and just from your perspective, and as the advocacy and discussion leading up to Dodd-Frank, how much was, were folks at the state level focused on the preemption set of issues versus the set of issues that Andrew raised, which is this, really creation of a new series of new federal entities, the transition of powers, but also in areas where there hadn't been substantial federal regulations, whether it's the derivatives market, that the feds were now going to become a major player, whereas even if the states hadn't been major regulators there, they had clear sailing.
So I think Andrew raises some really important points and different ways you can look at preemption of state authority and this erosion of and nationalizing of erosion of state authority and nationalizing of federal authority. You'll hear, so I would say there's truth to both points. I'll share with you my perspective on where it felt like we really were and where it feels like we really are now. So as it relates to preemption and, did it really just kind of codify and slightly roll back the OCC's preemption? That's going to be up to the courts to decide. But to give you a sense, I've never seen folks fight so hard. It was probably one of the most contested provisions of the bill. And large banks tried to kill it till the very end. And I don't think they spend all that energy when there were so many things on the line over something that really didn't do anything. To be more specific, codifying Barnett means really different things to different people. The OCC interpreted Barnett, they kind of cherry picked out some words and they say, this is what Barnett means. Others of us say, no, more narrowly, this is what it means. So the courts are going to decide what the preemption standard is. It did not entirely roll back OCC preemption. It narrowed it, it held it to higher standards. It did roll back, where I clarify one thing, it didn't codify the Waters decision, it rolled it back. So operating subsidiaries are now subject to state law. So that was a rollback of authority. It codified Cuomo, which was in favor of the states. So rolled back one against the states, codified one in favor of the states, and then trimmed the sails of the OCC around preemption for the national bank. On the non-bank side, we were very focused on that. Non-banks had been an issue that states tried to address. So there was an evolution of state authority and kind of a continued piling on that we were experiencing of, well, now you need to do this, and now you need to regulate that. There was a fairly new phenomenon. Mortgage lending really changed over the last 20 years in terms of origination channels, all that. It's hard to separate out that non-bank from the bank piece. So what was happening here in Washington was banks are the problem, non-banks are the problems, let's regulate the non-banks. And that was on both sides of the aisle that we were hearing that. They're deeply connected. Non-banks were funding loans that were purchased by banks, sold to the secondary market. Banks were providing the wholesale funding to non-banks. It was an ecosystem. And where we tried to attack one, it would just kind of pop over in another place. And we were doing it inconsistently and imperfectly. But we saw the consequences and the need to act. What Dodd Frank did, in our view, and you have to kind of look at just prior to Dodd Frank, we in the states supported, recognizing that there was an attempt on both sides of the aisle for a complete federal takeover of non-banking. The OTS was looking to become the mortgage regulator, and support for that was developing. So the state supported something prior to the passage of Dodd Frank called the SAFE Act, which said, states, this is what mortgage supervision should look like. There's flexibility to move around here, but these are the authorities, the enforcement authorities, the licensing standards. You need to have background checks, and you need to have testing and education. If you do this, you keep this authority. If you don't do this, it gets federalized. 50 states got together after the passage of that and came up with pretty much exactly the same standards. We were working with the states prior to this becoming law, trying to pull together information and centralize background checks, centralize records, all this sort of stuff. So when states took enforcement actions against these non-bank originators that did some really bad things, that it would stick. They wouldn't pop up over here, over here, over here. So that context is important. The states were trying to do some things, coming together. Congress, and this was Representative Backus on the House side, and kind of driven to the finish line by Senator Martinez from Florida, Democratic support from Senator Feinstein, to give states an authority. That was then codified in Dodd Frank with the creation of CFPB. It forced the CFPB to recognize, all right, if the states are doing this, then you need to work with them. You should look at large institutions. In these three areas, you're responsible for the whole industry. In these areas, you're to look at larger institutions. States have enforcement authority. States, look to the systems they create and the examinations they create. So it forced more of an interconnection between the states and this new agency than we were expecting coming into this, where there was talk of a complete federal takeover. So Andrew's right that there was further erosion, and we're worried about that because whenever we see rules come out of Washington, they're trying to address so many situations that they're very complex, hard to comply with. They become a high barrier to entry or drive participants out and result in consolidation. That's a problem for us. We were trying to work within what seemed to be a steamroller coming at us and trying to get the best outcome considering that, and recognize that there were failures at the state level and federal level that we needed to address too.
Andrew, I'm interested from your perspective. Obviously there was as you talked about, there are 1,900 plus pages that don't deal with preemption and Dodd Frank. How much from your sense of the advocacy that you heard from, how much was focused on these set of issues about sort of the state and federal power? Was that a major issue for some of the players, or was it much more subsidiary to some of the other things.
Yeah, it was there was certainly a lot of discussions of allocations of power. In fact, I think those are probably the central discussions. But in many cases, actually, it was interesting enough, and maybe this will make the states feel a little bit better, is that it was also concerned about the loss of congressional power, because Congress was being asked to delegate so much of its authority over to particularly the Consumer Bureau and the federal agencies. And
Last I checked, given their approval rating, people were probably all for Congress giving away some power. But
yeah, the critique would be, it's also, if you want to live in a democracy, who makes the decisions? And so there was there's a very serious debate about whether or not, who should be deciding these issues, elected representatives or agencies. And that was a contentious issue, and on how broad that authority should be. Certainly with the states, I think particularly on our side of the aisle, there was a lot of concern about the proper allocation of federalism, and it was an issue that when we established the CFPB, I know there was a lot of concern on our side that Congress didn't spend enough time thinking about whether or not it got the right balance, and whether or not just simply granting such broad grants of authority to the CFPB was unwise, would unnecessarily preempt the states, and effectively over time make the states merely kind of enforcement entities for federal agencies, particularly the Bureau, as opposed to being independent decision makers and coming up with their own regulations and policies for their own states.
I mean, this raises an issue, and some of you've got scholarly and other commentary out there that talks about how you think about preemption, clearly delineated by Congress, and then the preemptive effect of federal regulations. And you saw during the Bush administration issues related to preemption and regulatory preambles and litigation over that. But I think there is this, fundamental question that this raises, which is how do you make we understand how you make Congress accountable, notwithstanding the challenges of incumbency and we don't usually get a lot of turnover in Congress, et cetera, et cetera. Obviously our constitutional system was set up to create a measure of accountability for our elected officials. But how do you actually make federal agencies accountable, particularly with respect to distribution of power and federalism? And I guess I'm interested from both of you, and I'll speak on my own thoughts, how you actually create a system or create a level of engagement that makes those agencies accountable. And I'll also speak now in the private sector as somebody I think representing private clients, and particularly of interest I think to the ULC, which is, look, one of the biggest challenges and frustrations I think is that I hear from private clients is sort of not knowing how to engage. It's not a question about, everyone knows how to file comments, notice and comment to a proposed regulation. Everyone knows how to go to Congress and say, I want to repeal Dodd Frank or whatever, pick your major piece of legislation. What is a much bigger challenge is how you get into sort of the in-between questions of, okay, what is our approach to regulating this area and how can we make this most sensible? And that's, I think, a place where groups like the ULC come into play, because there is in some ways a surprising alliance between some of the, I think, private sector interests and folks in the states who want sort of, want to find a sensible means of regulation. But people have trouble figuring out where in Washington they are to go to sort of have this discussion. And like I said, I've been I've been in private practice for all of 4 months, and I get this question in different industries in a host of different ways, but they all are some version of the same, look, I got a lot of people trying to regulate me. They don't seem to be talking to each other. Where do I go to get everybody together and sort of figure this out? And so I'm interested from sort of both of you all about this question about making federal agencies that are regulating accountable, both to obviously the regulated entities, but also to the people in the states who are looking to enforce the law sensibly for their citizens.
Well, on my side of the aisle, making agencies accountable was one of the things I've spent a great deal of time on in the last 2 years, because the Republicans you probably are aware, have refused to confirm Cordray as the director of the CFPB until the agency is made accountable. And there are three ways that they've asked to change the law to make the CFPB more accountable. And that's probably, I think, the three things are: one, making sure that the agency is subject to appropriations; two, that it's a board; and then three, that there's a stronger check on its regulations. And those are three, I think, common ones. They're not the only ones, and there's lots of ways you can structure those three to make them more accountable. Clearly, it's easier to say what isn't accountable in many cases than what is. The way the Bureau is structured, you have one person for 5 years who largely determines his own funding and has effectively no check on the impact of its regulations. That's pretty unaccountable. Now you can think of other cases where the president, for example, has the ability to remove someone at will. For example, the comptroller can be removed at will by the president. That's not the case with the director of the CFPB. That's a big difference. If you look at cabinet officials who exercise a lot of regulatory authority, they can be fired at will by the president, and over our history, many of them have been. and in our military is actually another good example of where kind of direct dismissal authority makes people accountable. I think appropriations is another important one. Appropriations is the easiest way for which Congress and elected officials can exercise some accountability. And it's not accountability necessarily in overruling or decisions, but it's also helping allocate resources and making some of those decisions about how the agency is going to be governed and what it's going to do, what its priorities are going to be done. I suspect if the CFPB had been subject to congressional appropriations, there would have been a strong movement 7 or 8 years ago to increase its budget and its resources for going after predatory lending, because that was a topic that there was a lot of support for, and it was a topic that I think members were aware of. Going forward, they wouldn't have that ability, so it'll be left solely to the director's discretion on how to allocate. So it's a big issue. It's always tricky to come up with, and that's one of the challenges of the regulatory state: is how do you preserve your democratic institution while also allowing for a delegation of authority to an agency to handle kind of the day-to-day implementation. It's a key issue that our founders didn't have to worry about. They didn't envision the regulatory state the way we have it. But clearly, it's not going away. And certainly, the regulators do, in many respects, a fine job, and there's a lot of really talented people there. But we also have this principle of, if you want to have a democracy where elected representatives who can be held accountable by the people are the ones who make policy choices, we have to think about what the best way to make sure that those elected officials have proper oversight and can hold regulators properly accountable.
I couldn't agree more with that, and I think this is where federalism really matters, because if the only point of accountability is in Washington and it's oversight from Congress, with all that, and having worked on all that Congress has to do, they're not going to be accountable at the level that is satisfying to us on the local level. There just won't. It takes so much for an issue to rise up to the level of Washington to create the kind of meaningful accountability that we'd like. And so we're strongly in agreement that we need to preserve state authority and state accountability around financial services. As an example, and this is where, we're in the reality I live, I struggle over this issue. So I remember an experience where we were, over this preemption issue of predatory lending laws. We were up talking to the Senate Banking Committee, and at the time, the chairman of the committee was Senator Paul Sarbanes. So he sent a letter off to the OCC saying, "I disagree with your recent interpretation, your broad preemption of state law and enforcement of state law. for national banks, and the OCC came back with a letter that any of our commissioners could never imagine writing to the chairman of their committee of jurisdiction, which was basically, you're wrong. You're just reading the law wrong. And so that was a reminder of kind of a lack of accountability that could exist. And sometimes you sort of wonder how much of this is theater that's playing out for your benefit, and there isn't really necessarily the desire for the level of accountability that you're being given the indication they're seeking. But you know, the OCC is not an appropriated agency. Like us in the States, it receives its funding from the industry. Most of us in the States, it comes through the appropriation process. The flip side of this is we're often criticized, and this is where we are at risk and we really lose the most authority, is where we don't have adequate resources to have the sophistication through the examination process to challenge our federal counterparts, to really be held in high regard at the federal level. And that is, our folks are amazing, and they put up with some really challenging and difficult circumstances with furloughs and things like that, but they are not compensated to the same degree that their federal counterparts are. And it's been argued in Washington, we need to have qualified regulators. We need to have a sophisticated skill set to regulate this industry. So that appropriations process has accountability, but it's also been, for us at the state level, something that's actually resulted in our losing authority at the federal level, that state legislators have not given adequate resources sometimes to state regulators. So there's a balancing act here. And I don't want to be overly critical of the OCC in this regard. You need to find the right mechanisms. I think part of that is not just the appropriations process, but the federal government is accountable to the states, and we have some meaningful ways of doing that, still trying to facilitate some of the national goals, not some of, but the national goals that Congress has, that they've empowered federal regulators with where are they going too far? And I don't think we found the right balance around that yet. Certainly us coming together in the states and challenging this had consequences, and we've regained some authority. That's probably one of the most effective ways that we can do it, but there are probably some other ways as well.
From your perspective, John, how much of the positives that you've seen come out of Dodd Frank are a function of a combination of sort of the authority, the way the authorities are structured, but also just the relationships that folks have with, in particular, the CFPB, a new entity, obviously an entity where the nominee is, comes out of the states. How much of it is because of the character of this particular partner, and what do you see going forward? Changes of administration, changes in policy, over time, and interested in your thoughts on that.
I would say it's a little of both. But the structure and incentives at the federal level, and this is what we kept saying during Dodd Frank, and so Andrew points this out, that you have to have the structure right. So it doesn't matter who's in power, that you have the right kind of incentives and the right sort of balance. And so thinking back on my experience in working with the federal government, there were places where the partnership was better. Doesn't matter the administration. We have, we come from a very bipartisan or nonpartisan environment. We've got people with very different perspectives on things in the states among state regulators that work together, and it takes a certain amount of consensus, as you heard from the governor, to take positions. But our work with the FTC sometimes would be frustrating. You feel like they're trying to take credit for things, et cetera. But with the Justice Department at the local level, it goes back and forth. Or with FinCEN, the Financial Crimes Enforcement Network, you still felt like there was always some sort of partnership there. It's when the federal government got in the business of chartering institutions, which is rare and it's held to a select universe, that changed. And so I think since this dynamic has changed a little bit and the authority is split between the CFPB and the OCC around the larger institutions, it's going to change some of these outcomes and some of the working relationships. And we'll see how this works. We have our concerns certainly about this. A new federal bureaucracy with a lot of power worries us too, given the things that have been built into the law. And, I'm sure the folks that are sitting there have a lot to do with this as well. We're doing a lot of work together to try to create an architecture that's both efficient, mindful of the burdens on the regulated institutions, and cooperative. We'll see if that endures. The efficiency aspect and the burdens coming out of the federal level, we'll see. But I think some of the dynamics have been changed by the architecture that Congress created.
Andrew, thoughts on that?
I agree with a lot, actually, with what you said. I mean, I think the one place that I think that to kind of expand on John's remarks is on the role of federally chartered entities, because it's clear that across party lines, there's interest in having a national charter for banks. And that goes back 100 and some years, and back like the Lincoln administration, and it's had strong support over the years. And as the markets have developed, and we've had become much more national and now international markets, that charter has seen its value has grown. And so I think it's completely right. It's a balancing act. And trying to figure out how to have entities provide credit on a nationwide and potentially international basis can be very, very good for consumers. Lower prices, more access to credit. In that regard, the United States has done a very good job over the last 100 years in expanding the amount of credit available and at what cost. It's interesting that the crisis that we had was because there's so much credit out there and so many people could get credit. And if you just kind of step back, in human history, usually the problem has been that people haven't been able to get credit and get loans. And in our case, there's so much and it's so easy to be available that we have to be very disciplined going forward on the allocation of that credit. But that means, though, that we need to think about national institutions and how that impacts the demands of the markets. The world is not the way it was in 1789 with regard to financial markets. It's a completely different place. And I think one of the real challenges going forward, not only nationally but also internationally, is how to come up with regulations that allow for the expansion of international markets that we're seeing, but without losing the kind of local impact, understanding the need to have a local control and account for kind of regional differences. It's a very difficult balancing line there. It's something I indicated earlier. It's something we wish we'd been able to spend more time thinking about, because I think going forward, this issue is not going to go away. And, the easy solution is, well, we'll just have the Bureau or the OCC kind of figure this out. But I think we'd like to have seen more thought in coming up with having Congress give a little bit more consideration on what that proper balance is. And I think a kind of classic example on this is the resolution. We have
That's the big area.
huge issues, and with the failure of Lehman, one of the big technical problems was that so much of it, such a large proportion of its assets were located in London, and so you had to resolve it not only in the United States, which was a challenge, but then you had to coordinate with the UK. And I think that thinking about now not only nationally but that international component is really important, and that's where more thought I think needs to be done. The FDIC's done some work in this area, which is I think encouraging. But my experience in having sat at Senate banking, where we have the real luxury of kind of hearing from experts all the time, and kind of being able to hear kind of the cutting edge thinking. It's pretty clear that we need to do some more thinking about how to adapt our legislative and regulatory system to this kind of growing international marketplace.
And I have a couple thoughts on that. So this was the source of a great deal and continues to be of discussion within our organization. So there has been a sympathy with trying to facilitate multi-state operations. Foreign banks operating in the U.S. was a product of New York state law for decades, if not much longer, before it happened to the federal government, 1978, before the federal government recognized the ability of foreign banks to operate in the U.S. That said, we feel that the system has been focused so much on facilitating those business models that it's losing a sense of what, but you do hear about more debate. I don't think it's really focused as much as it needs to, and it probably will, on not just that business model, because it may deliver some benefits. It delivers benefits around areas of lending that can really be standardized. So, but we don't serve our country very well if everyone can get a credit card, but they can't get a job, meaning that small business lending is still highly subject to very tailored decision-making, and what we call in banking, relationship lending. You know the individual, you're willing to take a little more risk because you understand them, their business proposition. That doesn't lend itself well to a very consolidated model, and I think there's universal recognition across the banking system about this. But the more things, and there's been a demand, it's not as though large banks are looking for more regulatory burdens, but when they look at the choice between states responding to the issue and the federal government, they opt for the federal government. And it's because while these standards may be written in a way that are simple and easier for a locally based institution to comply with, when you add them on top of each other, a larger institution, it gets more complicated for them. The problem is when you nationalize that, it becomes so complicated for the local institutions. They have to hire lawyers that they can't afford. It's now coming to a point where, is this a tipping point where they can even stay in business? So this balance is, it needs to take many things into consideration, and that facilitating that global business model for large institutions isn't always a win-win, and we need to think that through very, very carefully. Our financial system, from our perspective, needs to serve our domestic economy first. I think, that a society that is all about its financial system is very problematic if you look to a couple of countries right now. So we need to find the right balance, and we haven't. And to Andrew's point earlier, more and more has been federalized. It makes it more complex, simpler for larger institutions, but more complex for others.
I think we're going to open up for questions. So for any of us on any topic. So please, if folks have questions, we've got the mics up there. I will just note, in 2 weeks, I'm going to be on a panel which is asking the subtext of what we just discussed, which is why not just do financial regulation on a global level? Why not have a global financial regulator? And obviously the SIFI aspect of this is a substantial component of that, but it's going to drill down into all these things. And looking at the ULC's sort of uniform principles and the discussion of federalism, trying to figure out the protecting state and local authority in the context of federal treaty, as well as central bank to central bank discussions, et cetera, is going to be a challenge in the years to come. So, do we have some questions?
Yeah, I was wondering what percentage of nationally chartered banks actually engage in interstate banking business, because there is a distinction between interstate banking and simply getting a national charter. Lots of tiny code-owned banks have a national charter. And a big question I think the nation needs to ask is whether the national charter should be a license for general immunity from state regulation, when many of the holders of a national charter really don't have any of the characteristics that require uniform, harmonized national regulation. So do you happen to have a sense of what percentage of nationally chartered banks actually are Citibank-style banks rather than Bank of Los Alamos? National bank?
It would be a small percentage of all banks, and there's a good number of state charter banks that operate on an interstate basis as well, subject to a kind of hybrid of applicable state law. So I won't go into that, but so it's a small percentage of both charter types. But I think what you also hear, it's a significant portion of the assets, and they've consolidated more under large institutions, those assets, and huge percentage of the assets of our banking system are in a handful of banks that are almost all have varying levels of interstate activities.
Right. You'd also follow up on that because this discussion oftentimes just focuses on national banks, but also applies to other federal chartering entities, and Freddie and Fannie being kind of classic examples. They drove a great deal of the market, and this is going back to my earlier comments that I don't think Congress spent enough time really thinking about getting that balance right. Yeah, there was some discussion about the role of national banks and the importance of having national markets, but how does that relate to the states? There was no discussion about the role of Freddie and Fannie, and overall, in particular, about its relation to driving lending standards, conduct of business, because that Freddie and Fannie for most state and non-depository mortgage lenders, they're the key player for them. Not part of the discussion at all.
I have a question actually about what I think is a sort of little notice provision of Dodd Frank, but since you, I think, spent probably more time than anyone else, at least in the room,
Don't remind me.
looking at it. There's a provision that transforms the OCC from an executive branch agency to an independent agency, which could have been done for a variety of reasons. Academics tend to be very interested in these kinds of questions, and I'm wondering what insights you have into why that was done and the likely effect.
Yeah, first of all, I'm impressed that you caught that, because I thought our
Administrative law professors do.
yeah, it was a big change, and it was something that one of the counsels and the staff came to me one day and says, "Do you know what they did?" I said, "What?" I said, "Well, look, read this." And I read if you read the title of it, it doesn't really indicate. I was like, "Well, what is this?" And then we went down and looked at it, and we're like, "Oh boy, this is a big change for the OCC." And this, just for the people who aren't familiar with this provision, historically the OCC was a bureau within the Treasury Department. There were some laws that insulated it from having to report to the Treasury Secretary and so forth. Dodd Frank, though, has a very small provision that effectively makes the OCC now a separate independent agency, and that changes its relationship. Most significantly, it no longer has to have its rules go through OMB, which is another issue. If you talk about balancing on regulators. The whole idea of having OMB was to have one central entity that could coordinate policy for the federal government. Our federal banking agencies are now largely outside of that, so they are on their own, so to speak, and even further removed from both Congress and the executive branch. And I think that's a really significant change that did not get sufficient attention during Dodd-Frank.
Yeah, I will say I do think that it was a reflection of the operating reality, right? In other words, if you'd asked even people who were intensely knowledgeable inside the executive branch, they would have had to go look up whether the OCC was an independent agency or not. And then they would have had to gone through all this research to figure out, why essentially the question, well, why can't the Secretary of the Treasury simply tell them what to do, came up frequently. And the reality was, through some legislation, some sort of custom and course of dealing, it operated effectively independently. This is a broader set of issues, and I do agree it goes to this sort of accountability set of issues. I'm sort of an old line traditionalist, which is I am always concerned when the creation of independent agencies, which I accept, we are told, is because it insulates things from politics. My view is, you elect a president, that person's accountable, and the more things you remove out from under the president's ability to control, I think you raise real issues about accountability.
One additional anecdote on that point too, on why it was significant to me, is that when I first came to the committee, Senator Sarbanes and Senator Shelby together had serious concerns about the Basel II capital accords. And there was some research done that had shown that Basel II was going to lower the amount of capital banks were going to have. This is 2005, 2006. So think about the time frame. And they pushed back significantly on Basel II. One of the reasons they were able to do so was because the OTS and OCC's rules had to go through OMB. That slowed up the process, and that actually allowed Congress a chance to weigh in and say, "Wait a minute, what are you doing?" And gave us time to push the regulators to include several safeguards on how far capital would be allowed to fall as Basel II is being implemented. If you think about how undercapitalized the system was before or during the crisis, imagine if that had gone through without the safety checks that OMB review actually provided. So that's why for us it was we knew immediately what the significance would be. Is that from now on those regulations will move a lot faster.
It was about the OMB review, and the agencies, the federal banking agencies worked together, the Fed, the FDIC, then the OTS and the OCC. We participate in something around that as well called the FFIEC. I think this points out some interesting things in terms of the checks and balances of government. The FDIC, and we were working very closely with the FDIC on this because we were concerned about Basel, drove a lot of that criticism, and the Fed and the OCC, more interested in global harmonization and national standards, was much more eager to move Basel through the process. So this is something where we need to think about that global harmonization as well as what we're losing in the process, or centralizing even further. There were talks about a single federal regulator taking away the authority of the Fed and the FDIC and putting it in a single agency. We need some of those checks and balances.
You haven't commented on the role of the private industry in driving the preemption. Let me give you an example. We look at the history of the banking regulation and the preemption of state laws. It goes back to the Marquette Bank case, the Barnett case, the Michigan case. Basically, they preempted all of state regulation dealing with consumer protection. And then the control of the currency didn't seem to enforce it. I'll give you an example of that. About 2007, 2008, LAABA always had a bank law seminar, and I was at it, and the senior officials from the control of the currency and everybody else there. And having been a bank board member and so on, I asked them why they weren't enforcing the lending standards or the obligations of a bank to make sure they don't make unsafe and unsound loans, specifically with regard to the housing loans at that time. And the control of the currency official said, well, banks aren't the only ones making those loans. I understand that. But they didn't enforce their own rules, and as a result, you see what you got. So when you talk about the preemption, I look at what's being driven by the private industry, by the major banks that brought these cases, that chipped away at the authority of states, and the control of the currency really being in their thrall and not enforcing the rules. And so the result of Dodd Frank is you got this Consumer Protection Board, which or committee, whatever it is, that may enforce some of those rules, but basically, I saw the preemption by the federal government taking away the role of the banks, state bank regulators in enforcing consumer protection laws. And also, I'd been on a bank board, but I also, for 6 years, chaired the Minnesota Senate Committee dealing with banking, insurance, and securities and all that. So I have some experience in that, and also in representing banks after I left the Senate in regulatory issues. But I'd like your comments on the fact that the preemption seems to be driven more by outside forces than by the government or the state or the federal government.
I think we're going to have to close up after this one. Do you guys have some quick comments in response to that?
Well, it's true.
Yeah.
I can make the answer longer. It's true.
I mean, as much as people complain about the burdens of federal regulation, there's an awful lot of federal regulation that I think folks would say has the effect of being deregulatory. And that, I think, there's scholarship on this that sort of discusses this, and it is, but I do think we are, this is an area where the interesting interplay, particularly with domestic and global regulation, I do think we're moving into an area where you're going to have large institutions, whether they're banks or other types of institutions, where they're going to be, their big focus is going to be having the most uniform set of laws that they can find. The focus on who's actually doing the enforcing is less important than knowing one set of rules of the road that they're playing by. And I hear that over and over again now. The proof's in the pudding, and when you actually get to discussing like what a regulatory regime would look like, you're going to find a lot of consternation. All that being said, I do think that, like I said, a group like the ULC has an enormous role to play as we go forward in a very complex environment. So I want to thank everybody for the questions and listening kindly to us. Thank John and Andrew, and we will exit stage right or left and let the next panel come up. Thank you very much.